Mr. Speaker, the Inland Revenue Authority of Singapore, or IRAS, is the government agency responsible for the administration of taxes and enterprise disbursement schemes. IRAS has been an efficient tax authority and has a consistently low cost of tax collection at less than 1 cent per dollar of tax collected over the past decade or so. In recent years, this has come off quite significantly, to around 0.63 cents per every dollar collected in FY 2022 from 0.82 cents just 2 years ago. This perhaps is also reflective of the significant increases in IRAS tax collections over the last 2 years, a jump of around 38% to 68.2 billion in FY 2022, with FY 2023 set to be another record year of collections, as we could soon find out in the upcoming budget debates. In my speech today, I will first touch on the broader picture in IRA's role surrounding the administration of grants before following up on specific provisions of the bill. IRAS today is already responsible for administering enterprise disbursement schemes and is in fact also designated as the Centre of Excellence for disbursing broad-based grants to enterprises. These include the administration of enterprise schemes such as the Progressive Wage Credit Scheme, Senior Employment Credit, and CPF Transition Offset. During COVID-19, IRAS also supported the administration of the Job Support Scheme, Jobs Growth Incentive, Rental Cash Grant, and the Rental Support Scheme. As described in the explanatory statement of the bill, the amendments aim to provide for the recovery of any money, credit, rebate, or other grant under schemes introduced by the government or statutory body that are specified in the new second schedule of the Act from recipients that are not entitled to such monies. In other words, wrongly given grants. To me, this begs the broader question that had such recipients not cooperated with the government in the past, were they legally entitled to retain these grants, given that these were given to them not as a result of deceit or fraud on the part of the recipients, but some form of administrative oversight or mistake on the part of the authorities? There were the recent cases of overpayments in the Job Support Scheme, where the wage support grants were erroneously paid to about 5,400 companies in October 2020 due to mistakes in computing the disbursements. These amounted to about 370 million. Subsequently, it was reported that the government has recovered over 99% of the 370 million wrongly paid to companies, with the bulk of it recovered through offsets against firms. Subsequent JSS payouts were applicable, as well as returns in cash by large enterprises. The issue of overpayments was also an area that was highlighted in the thematic audit by the Auditor General in its latest report, which looked at key COVID-19 grant schemes, the Job Support Scheme, the Rental Cash Grant, and the Rental Support Scheme. The issue was also part of the discussions by the Public Accounts Committee, which I'm a member of. In any case, MOF had updated the committee that MOF and IRAS have taken steps to investigate and recover the overpayments, which made up less than 0.5% of total payouts across 3 schemes. Overpayments in relation to government-funded entities were fully recovered. On the other hand, in cases of abuse of such government grant schemes or grants which were fraudulently obtained, it is important that IRAS be empowered with investigative and enforcement powers to deal with such offences to safeguard public monies. In response to a parliamentary question on cases involving the abuse, misuse, or fraudulent application of COVID-19 grants and payouts, it was shared by MHA Minister that from March 2020 to December 2021, the police received 57 reports involving the abuse or fraudulent application of COVID-19 government grants and payouts involving approximately 1.7 million. Following the various reviews conducted by IRAS and the MOF in recent years, and after internal processes highlighted in the AGO report are refined, does the Minister have further information to update on the cases of abuse uncovered and the money subsequently recovered? Moving on to specific provisions of the bill, Section 17D of the proposed bill provides for IRAS to charge interest on the overpayments that it seeks to recover from recipients. Given the overpayments were not the fault of recipients, what is IRAS' approach in the recovery process, and how much leeway do companies have before interest is being levied on them? Moreover, given that interest is to be calculated on a daily basis, from the end of the payment period to the date that the claim amount is paid in full, this could rack up to a substantial interest charge. What are the indicative interest rates under consideration? How much interest was charged for COVID-19 grant recoveries, and whether such interest payments can be waived should there be a good faith attempt to make the repayments. This is especially considering Section 17C, where a payment period of 30 days is proposed after the date of service of a written notice to the recipient is served. While the bill did state that there can be a later time that the authority may allow in a particular case, the tight timelines can be particularly onerous on companies who may be facing severe cash flow difficulties, or SMEs which may not have as established administrative and finance processes in place, particularly if the amounts in question may be quite substantial relative to the recipient's financial position. All that being said, notwithstanding my clarifications, I support the bill.